Point number 1. Any candidate shall be allowed to apply for the post of a primary school teacher of a particular council only against the post advertised. Particular council he can choose for the form. And then you'll also see the next form fill up. Now you'll
No, what is your interpretation? Any candidate shall be allowed to apply.
Any candidate shall be allowed to apply for the post of a primary school teacher of a particular council. So council was not fixed. He can choose any particular council. A candidate of Kolkata council can choose for Darjeeling council. For example, I'm saying for a particular council for the post advertised. Now your losses kindly see the application in the next.
Where?
Losses will find after email ID. Your losses will find this roll number 19. 19 stands for District Birbhum code. Roll number. Second column, your loss. Second column. This is state roll number, my lord. 19 stands for Birbhum.
Date you said that there was a unique number.
This roll number was treated all along by the board as unique identification number.
When the number added with this district code.
District code.
Then what is your argument?
Argument is that, my lord, a particular candidate, this number 19 or 18 denotes the particular district he applied for TET. Now he has been given option, he can choose another district with this roll number. That's your lordships in this application form. Kindly, my lord, go little down. Email ID.
Yes.
Just thereafter. Preferred district for counseling, recommendation and appointment. If empaneled, he has chosen Kolkata. This particular candidate, I'm giving an example, chosen Kolkata.
All right. Yes.
The next one also. But all in this chart, your lossy, most of them belongs to the other medium, or most of them chosen different districts. So number cannot be equal. Cut-off marks, no, last empanel candidate numbers. There is no cut-off number. Cannot be equal. That's our submission. And Mr. Amit says all are Bengali media. That's absolutely not correct. Because showing that most of the, I can give example right now to your lordships. Some of them from Bengali, Hindi medium, some of them Urdu medium, some of them Telugu medium, Santhali medium.
All right. Yes, Mr.
Lordship, with your kind permission, Mrs. Arora is online. Your Lordship had said should start.
Yes, yes.
My lords, I'm so grateful. I will be very brief and just to the point because a lot has already been addressed before my lords.
Item number, mat number 1616. Mat number 1616 of 2023.
Mat 1616
of 2023.
Item number 28.
Item number 28, Lordship.
20. Yes, madam.
Please, my lords. My lords, I'll be very, very brief and only to the point because there's a lot that has already been addressed and it's no point in repeating the same thing all over again. My lords, the very first point that I wish to address, my lords, is that right from 1951, the Supreme Court settled a principle that if there is any allegation of fraud, coercion, duress, etc., is to be made in any pleadings, it has to be supported in material particulars. And
Yes.
there, my lords, there are two judgments of the Supreme Court. My learned colleague will pass them on. I will.
Please, madam, you reply we will take note of.
Please. Yes, my lords, I will just give the citations and I leave it with the paragraphs. My learned friend will just mark the paragraphs and give it to my lords. I do not wish to this thing. Now,
Yes,
my lord,
please.
right in 1951, the Supreme Court said that if there is an allegation that is made in respect of fraud, coercion, duress, there has to be proper case. It has to be supported in material particulars. I will just read 3 lines of that judgment of 1951.
We accept your argument. It has to be.
I am great. I am grateful. My lords, I need not go further. Now, my lords, I respectfully submit that the writ petition, as was filed before this honorable court, of which the impugned judgment is the one which is under challenge before my lords, is bereft of any material particulars of so-called corruption or any kind of particulars to show that there was some case that was made out which would clearly establish that there was a corruption or there was a fraudulent action on any of the candidates. This I go back to the learned single judge. My lords, my next submission taking up on this is, and I say this with all humility at my command, and I don't intend to be rude, but if we look at the judgment of the learned single judge, my lords, it appears, and I say this with humility, and I repeat that, it is like prosecutor and judge in one. And that, my lords, is definitely not permissible in a rule of law. First of all, there was no material. The learned judge relies upon some sampler material, which the learned judge finds. So he takes on some kind of an investigation, and then he carries on the cross-examination of certain interviewers by himself, to which none of us who are the affected parties were a party or could have even asked any question. And on that sample material of about 30 odd investigators, and something like, I did a calculation of the numbers of the candidates in respect of which the learned judge has observed, is 0.03% of the total candidates who had taken the exam. And on that basis, the learned judge arrives at a conclusion that there is far-reaching corruption, and the entire exam of 32,000 who had been appointed should be set aside. My lords, today, when we are before my lords, the assumptions and the presumptions that the learned judge proceeded with have now been found to be incorrect in view of that charge sheet that has now been filed, where none of these allegations of corruption against any one of these 32,000 candidates has been made out. So, my lords, at the first instance, entertaining the petition was completely wrong, contrary to the principles that the courts have held in the cases of fraud, duress, coercion, etc., no material particulars. In a writ jurisdiction, the honorable judge could not have become an investigator, prosecutor, and a judge by himself. And in any case, the observations and findings of the learned judge have today been disproved by investigation, by an agency which has today investigated and found no allegation against us 32,000 odd candidates, my lords, and there is nothing which is against them. Now, my lords, I submit, that's my very first point on the background that I wish to place before my lords, that in view of this fact today, after having put in more than 8 years of service, to say that today all of them should be, my lords, asked to go would be extremely harsh and punitive without there being an iota of material or evidence on record. On the contrary, the contra evidence is there on record. Secondly, my lords, I believe, and that is what I have been instructed, that there has been much emphasis to connect this matter with the 269 TET candidates who were given one grace mark and the 94 other participants who were not qualified. My lords, I would most respectfully submit that both those matters are today's subject matter before the Supreme Court, number one. And hence, this court, with due respect, may not want to go into that particular issue once that is seized off by the Honorable Supreme Court. My lords, number two, neither the 269 nor the 94 form part of us 32,000 selected candidates in this process. Now, clearly, if they are not a part of this, I fail to understand in what context is the reliance being placed on those particular candidates who do not form part of the 32,000.
No, why do you say they are not a part of that? Because
My lords, the 32,000 who have been selected here, these are the ones who have been through the process of having the qualification of TET exam. So the 94 clearly do not have the TET qualification. They are the ones who are not qualified.
no, you have given candidates appointment by giving a grace mark.
I agree. But my lords, these
That
32,000,
applied in respect of all the persons.
my lords, no. So far as we are concerned, there those people had not qualified the TET. They were given one grace mark and made to qualify. But here in our case, all of us are TET qualified. We didn't need any grace marks to be here. We didn't need any grace marks to have qualified this particular exam. We came on our own merit. We had the necessary eligibility and the qualification. Our documents and our papers were verified, and thereafter we were subjected to the interview, as well as, my lords, the subject matter of our ability to impart education, the two tests of 10 marks each, 5 marks each, we were subjected to that. So, my lords, we are not in those category at all.
What about the 94 you were saying?
My lords, 94 are the ones who do not have TET qualification at all. They are not qualified. Their case was they were unqualified candidates. They were not TET qualified. They were only trained but not TET qualified. And by which time the NCTE had clearly made that TET was an essential qualification for purpose of appointment of teachers.
All right, madam. Anything else?
So, my lords, just two more very small points, and I will not dilate too long on that. My lords, issue were raised to say that the Tripura judgment, and there is similarity between the Tripura and the present matter, and in the Tripura case, the High Court had actually quashed all those appointments. My lords, I want to say there are major distinctions between the Tripura case and this case. First of all, in the Tripura case, there was a challenge to the constitutional validity of employment policy of that state itself. And my lords, that policy was contrary to the NCTE. Now, that is not the case before my lords at all. There is no constitutional validity challenge to any provisions or any rules. Number two, in the case at hand before my lords, it is the appointments are strictly as per NCTE guidelines so far as qualifications of the candidate, etc. are concerned. In Tripura case, in facts, the procedure was contrary to the provisions of National Council for Teachers of Education Act, which is a very important factor. Now, my lords, in our case, all the candidates have qualified, who are appearing before my lords, have passed the eligibility TET 2040. So, and after that, our academic marks were computed on a proportionate basis. We underwent the verification of all our documents, scrutiny, etc. And then, my lords, we participated in the interview and the aptitude.
Yes.
But in the Tripura case, my lords, there was only one interview that was conducted and nothing more was done. And it was a highly discretionary thing, which there was the finding of the court, but more particularly, it violated the NCTE guidelines, which are the central government guidelines for appointment of teachers. So one could not have gone contrary to that. One could not have gone contrary to the qualifications prescribed in the NCTE guideline. My lords, so far as the appointments are concerned, as my lords have now seen, and that chart sheet has been shown very extensively to my lords, there is no illegal appointments that have been found. Whereas in the Tripura matter, the selection and the appointments were found to be illegal. On the contrary, the learned single judge, based on a small data, a very, very small data, which was in a very summary inquiry, if I may say that, in a very summary nature. My lords, in a 226, one can't have an inquiry. 226 does not envisage that kind of an inquiry. Today, there is an investigation and a detailed inquiry, and which has categorically found that, my lords, there is no element of corruption, there is no element of complicity or to corruption here at all. My lords, the third point that I'll be very, very quick with is that a lot of parity was sought to be drawn with the SSC case. Because in the SSC case, the Supreme Court had set aside all the appointments. Now, there's a huge distinction and they're completely different and distinct. My lords, we must remember that in the SSC case, there was a written exam. Here, we have an interview and an aptitude test, and then we have a prior TET qualification, verification of our credentials, our documents, and thereafter we go for interview and our aptitude. In SSC case, I beg your pardon. My lords, that's my Delhi pollution showing up. So, my lords, in the SSC case, there were OMR sheets. In the OMR sheets, it was found on a fairly large number that there was actual manipulation. There was a CBI inquiry. The CBI inquiry actually reported manipulation of the OMR sheets. Now, my lords, please contradistinct that with the present case. In the present case, there is no written exam. There is no such manipulation of any answer sheets. And the investigation today has submitted a report which does not show any complicity on part of the candidates. So, my lords, to draw a parity or to draw anything from SSC exam, my lords, would be SSC candidates would be completely, my lords, misplaced, number one, and will not fit into the present case at all. That's another fact situation altogether. My lords, lastly, I would want to make a submission. My lords, there has been that can number 2 and 3 where certain
Yes.
documents are sought to be placed before my lords for the first time. My lords, apart from the fact that it has been said on this side that those documents are forged or they are not documents which are correct in nature, but I would, my lords, ask myself a question. At this stage, in an appeal, would my lords, without having any verification of those documents, allow such documents to be placed before my lords and to be considered? Then, my lords, I would most humbly submit to you that we fall into the same trap as the learned single judge did, because he went on the basis, and I would say that with all humility, he went on the basis of what was produced before him. And that has today been disproved by a detailed investigation. Similarly, these documents which are sought to be placed for the first time before yourself, having not been verified, not been authenticated, and specifically being alleged by the present petitioners before my lords as being forged and fabricated documents, I would request, my lords, that the court may proceed on the basis of the record that has come from the learned single judge, and please do not allow any fresh document or material to be taken on record at the stage of the appeal, my lords. My lords, I will lastly, I would, my lords, there was one other judgment, but I don't think that is necessary, that the honorable single judge could not have gone on the basis of any newspaper reports, because my lords have said it time and again that the courts will not take cognizance of an issues merely because they have been published, and that's not an evidence. That's really not an evidence.
Why you are saying newspaper report? It was not there before the single judge.
My lords, the learned single judge in his judgment and in those proceedings made observations that there's a lot of newspaper publications about alleged corruption and everything else. Now, my lords have held categorically, the Supreme Court held in large number of judgments that mere newspaper publications are not enough evidence to arrive at a conclusion or arrive at a determination that there is an evidence of, let me say, corruption or something. I'll just give my lords a citation. It's a 2020 volume 16 SCC 811. That's a more recent one. And the relevant paragraph will be 6 in that. My learned colleague will hand over that. So, my lords, but that's on the side wing today. It's an outlier, if I may say, at best. The core of the matter would be that there is today no material whatsoever to show that there was any kind of a corruption in this particular examination process, my lords. My lords, I'm extremely grateful for your time. I'm very much obliged, my lords.
15 to 20 minutes, not more than that.
Mr. Bandyopadhyay, then you address what Mr. Mojumdar we
Why,
told.
Milord, I addressed first. Your lordship said to me, "Milord, I cannot sit here
All
every
right,
day.
all
Here.
right, all right. Tell it.
Cannot sit here every day." The Milord, first point that is was hard, but at the initially I have argued that regarding the extension, relaxation in training, that Milord, relaxation in training was given by the MHRD till 31st March 2016 and 2026 September. There was no relaxation, hence the board could not have appointed. This is the argument. Now, Milord, your lordships will find that the rules relating to 2000 recruitment process do you have the extra copies? So,
2000 recruitment process.
2016 recruitment rules.
Yes, yes.
Yes. The process were enacted on 2nd March 2016,
Yes, yes.
and when the relaxation was still in existence. Okay.
Yes, yes.
Now, Rule 6.3 provided for the appointment of candidates with relaxed qualifications, untrained after the appointment of trained candidates. That your lordship on the paper book, but Rule 6.3 at page 114 of the paper book.
Yes,
That is
yes.
there. If required, I will hand over.
No, no, it
note.
is with us.
Therefore, relaxation was extended time to time, and within the extended time, all our clients, all these persons who are there, they have what their
Point. They were participating.
and to who will get this relaxation? Those who are appointed, not each and everyone. Those who are appointed as teachers.
Yes,
After appointment, they will get it. They get the and they have done it. Therefore, this they did not have the qualification. It's not that. And in the advertisement, I have pointed out. I do not wish to again that in the advertisement itself, it was said that this qualification has to be obtained within 2 years after appointment.
Yes.
This is one of
That is not disputed.
that is no dispute. Therefore, we are all trained. Now, my lord, one I have shown it also. Again, I am sorry, my lord, repeating. The Honorable High Court of Calcutta in WPS so and so Chinmoy Doli case permitted the state of West Bengal to appoint untrained candidates. The court's order is there. Untrained candidates as assistant teacher in primary school even after the period of 30.
Bandyopadhyay, that is
This
not
is also not this, but they have raised the issue. That's the reason. The point is this, Miller. Point is very limited. But with great respect to our learned friends, they wanted to make it more wide. But we do not have to go that such stage. Point is very limited, but they have traveled hither and thither, hither and thither. Naturally, if I don't give the answer, my lord, your lordships will say that I don't have any answer. I have appointed, I do not have given the reply unless the Mr. Bhattacharya had traveled so much. He is my senior.
that will be answered by Mr. Bhattacharya.
He is not there. Mr. Bhattacharya traveled so much. And in practically, he is so from Vietnam to Platinum, everywhere he has traveled.
That is not at least relatable to this case.
No, not relatable. Just Mr. Bhattacharya is there.
Entire proceeding becomes boring.
Yes, yes. At least with us, compilation. That is, I objected to your lordships. Observe that you will be given the chance. Lord, what is the law of pleading? Even in a writ petition, even law of pleading is very clear.
That you have
Pleading?
extensively argued.
Bharat Singh's case, I have argued that.
Yes.
Beyond that, no one can go. After completion, Lord, from the bar, one compilation will be handed over, which has become very practice of nowadays. And then in that compilation, so many documents will be given. That is not the practice. That is not the law of pleading. That is not the rule of law. In court, we have to be precise with the pleadings and the evidences annexed thereto.
বিকাশ স্ট্যান্ডার্ড চার্টার দেখিয়েছিল
beseech to your lordships, I will request to your lordships not to look into any other documents in this matter, excepting which are in pleading, or which were only in pleading. Even if the learned single judge has committed a mistake,
Hmm. Yes,
by
yes,
looking into that documents which are not part of the records, and for that reason which have not been allowed to revert even the other sides, these documents cannot be. And my lord, kindly remember one thing, that the first time we are before your lordships, we are not in the trial court. So we didn't get any chance. And at the time of argument, the documents are being handed over. How we will deal with? Not a single document.
yes,
My lord, Mr. Bhattacharya relied on Standard Chartered Bank's case.
yes,
That is 2006 SCC 94.
deemed pleading.
Yes, was rendered in an appeal under section 10 of the Special Court Trial of Offence related to Transaction and Security Act 1992 para 1. It was a suit wherein the deficiency of the pleadings can be covered by the evidence, but in the writ proceeding being summary in nature, such recourse cannot be permitted. There is a deficiency in pleadings. My lord, every witness have come. There is a scope to cross-examine, etc. Let's assume a pleading has been made vague.
No, it was a case under the Special Act.
Special Act. That's why I'm
Suit why you're saying?
no, Special Court.
Special court.
Section 10 of the Special Court Trial of
A
Offence.
suit.
No, evidence was taken. Evidence was taken. That was judgment.
Evidence was taken,
Evidence was taken.
but it was not.
Not a suit. Sorry. Wrong.
Yes,
Now, therefore, there the evidence. Why this evidence is coming court, regular court, that's a different part. Everyone is getting a chance. Then I can ask for this, all right, if with the entry being all persons, I will cross-examine them. My lord, your lordship.
Mr. Bhattacharya's argument, if we are not mistaken, his argument was what are the elements involved in this matter? It encompasses corruption, fraud, etc. So, Mr. Bhattacharya argued that it is a settled proposition of law that suppose A, B, C pleading is required. You have made A and B. You have made pleading as A and B. So, for the specific C pleading, you need not reject it on the ground that there is strictly no pleading to that.
My lord, what is a pleading in a writ proceeding? Can it be vague?
No, on the contrary, your argument is that the original pleading remained. There was no amendment to it.
No.
What has been done in this course of action, deemed pleading would not apply.
May I, in short, his case, kindly see what he is asking for, what their clients are asking for.
Yes,
Their clients sought for certain
similar
considerations. Their clients did not ask for cancellation of any of the employment.
Yes, yes.
Correct. Now, when they have not got it, now they are saying, since I have not got it, soon no one will get it in West Bengal. I have become unsuccessful. Naturally, you will not be no one. And this word is very spicy word, the corruption. Corruption has to be proved. This is in Bengali, which is called chutney.
Yes.
The point, therefore, is before a lordship, whether before the single judge any corruption was proved.
Yes.
Not a one chain. It is a complete, corruption is a complete chain, not the picking up of the one thing.
Yes, Mr. Bhattacharya.
Now, is there any case has been made out that my clients have given money and got the employment or not? In the gist.
Yes.
That corruption has been proved. That CBI has said.
Yes.
Some persons have got it. Who are the persons? Dealing with the 32,000 cases. 32,000 persons future. Now, my lord, next one is charge sheet of the CBI. My lord, I have argued extensively the charge sheet of cited the judgment to your lordships also. Judgment I have cited.
Hmm.
It's an opinion only.
Hmm.
That has to be proved. My lord, I cited the judgments. I do not want to repeat. Can an opinion can be relied upon to terminate the service?
Yes.
My lord, in our compilation, I have given it 2022,
What is the name?
volume 12. There is Rajesh Jadhav and another versus State of Uttar Pradesh. Come to Milord paragraph.
So Rajesh Jadhav,
I have cited Milord. I have given a separate compilation of
no,
the
no, no,
judgments.
we have taken note of. You have cited that Institute of Chartered Accountant, then Khetrobasi Biswal, Boluram, then Ranjan Kumar.
These are
This
different
Raj, what did you say? Printers Mysore, Chennai Metropolitan,
This is different.
Murli Babu.
Ogula delay.
No delay. Yes. Now this chart sheet is an opinion you have not given.
No, Milord, I have cited that. Milord, your lordship
Can
will
you
find
give
it.
us the reference, please?
We will give it, get it in my compilation.
2000.
344. My compilation 344. That is at page
No, the name of the
2022, volume 12, SCC, page 200. Rajesh Jadhav and বড্ড কথা বলছিস রে।
SCC page 200.
আমি একটু ডাল হেডেড ভাই
Yes.
প্রবলেম 2022 volume 12 SCC page 200
Paragraph.
paragraph milord 27 তাই তো
7.
paragraph 27
All right. Yes.
but just I can just want to remind to this proposal milord section 173 CRPC calls upon the investigator to file his final report before the court. It being a report is nothing but a piece of evidence. It forms a mere opinion of the investigating officer on the materials collected by him. He takes note of the offense and thereafter conducts an investigation to identify the offense, the truth of which ones. Therefore, it would be lead to the position that the evidence of the investigating officer this evidence of the investigating officer is not indispensable. The evidence is required for corroboration and contradiction of the other materials witness, as is the whole links and present. Even assuming that the investigating officer has not reposed before the court or he has not cooperated.
Yes.
Now, therefore, it is an opinion stage. Trial has not yet been concluded.
It is tentative.
Trial has not been concluded. Therefore, your lordships, the corruption charges have been made. Let's take it. Your lordship is deciding the case in the civil side when charges have not been proved. On the contrary, today, what we see, all the accused have been enlarged on bail. That doesn't mean he has not committed an offense. I am not saying that. Also, I am saying that doesn't mean the charge sheet is given, that's a sacrosanct.
Yes.
Now, my lord, if the CBI was really serious, take the case, my lord. If the CBI was serious, this case is now pending for 4 or 5 years. They could not have finished the trial.
That is a
Separate thing. But I am saying, my lord,
we understood your
corruption, mere saying of corruption will not do. That's a separate issue. But I am saying so, my lord. Because these are the very corruption. To prejudice a court is this word is sufficient. But court will look into that, whether corruption has been established or not. That's my submission.
Yes, Mr. Varma.
And the corruption has vitiated the selection process. Maybe corruption, but here the corruption has vitiated the selection process or not.
Yes.
Right? Now, my lord, next.
আরো নেক্সট আছে
দরকার নেই তো এটা বলা হয় Namely, the litigations for 6 marks have been taken an argument. 6 marks have been granted. Charge sheet has been shown that the 6 marks have been given extra. Correct? That has been pointed out also. My lord, kindly remember, my lord, I can give the references also. This litigation for granting 6 marks, lead matter Pratibha Mondal, versus State of West Bengal were moved by Mr. Vikas Ranjan Bhattacharjee, Mr. Samim Ahmed, Mr. Sudipto Dasgupta, Mr. Firdaus Samin. They got the order from the High Court, 6 months to be added.
Yes,
And in the charge sheet has said extra 6 months have been given.
very good.
কি দরকার জজ সাহেব এখন তো চার্জশিট দেখাতে গেলে তো হবে না it will take time 15
Yes,
but I will give this orders copy. I will give it to your lordship. Who got this order from this court?
no, Mr. Bandyopadhyay, that is not required because your argument is that it is an judge sheet is an opinion, it is tentative
But-
on the basis of
Very-
that is
very
your
nice,
argument.
very nice, very nice. I am just
No, as you are,
my lord, I am who is on which side is very difficult now to understand.
to track it by.
For not conducting the aptitude test, then selection cancel of the selection process only for untreated candidate is only bad in law. Untrained, trained, all everything will go. These are practically possible now at this stage to after 2016 to 2025.
Because the trend also faced aptitude test.
Yes, same. Only extra. The trend is also having the certificate. We untrained also obtain the certificate. Therefore, your lordship is facing with the problem. If this acceptance is taken in, there are more than 60,000 teachers will go.
Hmm.
40 total. 42,000. Sorry, my lord. Not only us. Neither untrained was made party, neither trained was made party before the single judge.
Yes,
And unfortunately, my lord, this is a very unfortunate for us. Although the board is represented by here the learned Advocate General.
he has left.
No. I will not blame him because he was not there at the initial stage. Neither Mr. Rahul.
Like,
Ratul was there in the. See the proceeding. From the very beginning, board did not contest the case at all. Not a single thing has been said. The council who appeared at that point of time.
he put this question to Mr. Dotto, Mr. He has,
Our anxiety is that, my lord, everyone was not required to be calm before the court. But when states and the state authorities are represented, my lord, my lord, society expects everybody's case will be argued properly.
yes, Mr. Bandyopadhyay.
Next point, my lord. Citing examples of few irregularities cannot be ground for setting aside of the 2000 selection process.
Citing?
Few candidates.
Oh, yes. That you have argued, Mr. Bandyopadhyay.
No, this point I did not argue. They have
Yes.
taken, but it was lordship's
So
point.
point,
My lord, it was your lords, my lord Justice Chakraborty's point. Lordships have argued. I am grateful to your lordships.
no, we have not argued.
Not argued. Your lordship have,
Don't put
no,
the blame on-
lordships,
No, Mr.
not argued, not. I am sorry,
Mr.
missing.
Yeah, yes,
sorry.
Mr. Anindya Mitra and
No, here
that gave the
this observation had fallen from your lordships.
No observation.
Very good. I am with
No.
very nice. Now, few incidents.
Yes,
Can it be a ground? Few incidents.
yes, that.
Then when you are taking the 32,000 employees employment, you prove it 32,000 case.
Yes,
After all, it is a litigation.
yes, Mr.
Miller, this I'm coming. Do not documents regarding publication of panel. The writ petition, kindly see. Writ petition itself in 2009, Miller 19.
Monica Das or Robiul Sheikh.
Niladri Jana.
In the bunch of Rabiul Sheikh, actually.
In the bunch of Robil Sheikh.
Huh?
Here is,
Hard with Rabiul Sheikh.
it was hard with Robil Sheikh.
Oh, it was hard with Robiul Sheikh?
Yes.
Yes. What you're
Brother,
saying?
কোথায় দেখা
Rabiul Sheikh and
আরে তুই এখান থেকে দেখা না তুই অন্য জায়গায়
paragraph 35, 25 and 26 annexure আছে।
ক্যানেক্সারটা দেখা
Right there before.
35, paragraph 35. আর কপি আছে? দিয়ে দাও।
আপনার
Your
জন্য-
petitioner says,
আপনার জন্য আছে এখানে।
কোথায় কি রাখছিস?
Paragraph 35
হ্যাঁ, paragraph 35 of this kindly take the kindly
of Robiul Sheikh. No,
Niladri. Tagged matter, Niladri.
one judgment was delivered, no?
Niladri Jana. But I am saying the petition.
But the judgment was only in respect of Robiul.
Common judgment.
Common judgment.
Please, oh, no, please
আছে,
check up.
আছে, আছে,
I
দেখি,
think it
স্যার,
is
দেখেন,
only Robiul.
দেখেন স্যার, রবিউল শেখ সাথে নীলাদ্রি জানা।
No, no. No, no. Robil Sheikh with the Niladri Jana. It is there. 2023 SCC online, page 710.
Where you are showing.
Pilot, kindly come to paragraph 35, no?
35
Paragraph 35. Your petitioner states that from the published panel of the district Dokhin Dinajpur, it has been seen the lowest score obtained by candidates are entered at is 16,000.436 over the lower course score so and so. The your petitioner states that those marks are higher than. Then, unless you have seen the panel, how can you do it? How can you make this pleading? Next paragraph is কোথায়?
25 26 এ আছে।
25 তো পড়া হয়ে গেল, 35 তো পড়লাম।
হুম।
তাহলে কোনটা?
প্যানেল গুলো 124 থেকে আছে।
Bharat, kindly come to page 124.
Back right.
Is not readable, but see, from 124 the panel has been annexed.
ইন্ডেক্সে লেখা আছে
Panel, and kindly see in the index.
লিস্ট অফ ফটোকপি অফ লিস্ট দেখো।
Bharat, kindly come at the top of the
No, the judgment, was it a same?
batch
same
matter,
judge-
batch matter.
Acha, acha, acha.
Bharat, this is a,
Page 124.
yes,
ইন্ডেক্স
This has been told to us, Mr. Bandyopadhyay, that the panels were annexed with those
Yes.
restrictions.
therefore the panel was not published, it was not the case.
You publish one.
আরো বেশি বলিস না, জজ সাহেব বেশি চাইছি না। আর কি আছে? বোর্ড বলে দিয়েছে, এগুলো বলে দিয়েছে, বিকাশ বলে দিয়েছে। But these are the points, Milord. Almost every other, my other friends all have dealt with. I don't need to repeat it. Milord, I will just beseech to your lordship, Milord, I will sum up and I will say to your lordship.
Yes.
Kindly just. My lord, these 32,000 persons had been employed right for 2016,
70.
17, and 2000 selection for 2017. This is continuing. First round litigation, second round litigation, all have gone. Milord, very recent, Milord, Justice Joymallo Bagchi's judgment, did I cite it? Justice Joymallo, precedent that I'm repeating. Milord, one of the judgment I cited that is delivered by in the Supreme Court by Justice Joymallo Bagchi. Binding precedent has to be followed. Litigants should not be forum shopper. Renuka versus State of Karnataka, 2025 SCC online, SC 970. Now, when Justice Mousumi Bhattacharya was taking matters, 970, paragraph 17, I cited this judgment.
That was a coordinate versus coordinate, not a single bench versus coordinate.
No, no, what is the proposition of law has been.
Proposition is if you are not agreeing with a single judge.
Proposition, binding effective, see, proposition,
That is.
that binding effect is there. The one of the word used expression has been used forum suffer, which is applicable in this case. There are a number of judges who have taken the matters of this, not removed. Justice Mousumi Bhattacharya, Justice Amrita Sinha, even my Lord Justice Tapobrata Chakraborty was sitting singly. Even my Lord Justice.
Didn't take up this matter.
No. Education matter you have taken, na?
Shit.
That time it was not moved. I am saying it was not moved. That is, I am not moved. I am saying that.
Forum shop.
Then Justice Orijit Banerjee, Justice Hiranmoy Bhattacharya. The moment this jurisdiction has come, all that petition.
So why
This
you
is
are
called forum shopping. This is what I am not on that. I am not, I am using a legal expression, my
Yes,
lord.
forum shopping, yes.
Right? Forum shopping. I am not interested in any name. This name has no value now today. Now, my lord, next is now this is continuing, my lord. Would your lordships kindly consider? My lord, consideration before your lordship is this: whether the matter was decided in accordance with law by the court by applying all principles of law. By applying all principles of law.
Yes,
Or whether the single judge has adopted a procedure which is unknown to the settled law.
yes.
If it is not decided on the basis of the law fixed, it is taking away of the livelihood of others. My lord, 32,000 not before your lordships. 32 into 5. 1,60,000, 70,000 livelihood are at stake.
Yes.
Lord, this is my judge. I am just so grateful, deeply obliged. Your lordships are so kind to me, accommodated me. I am deeply obliged to my Lord Justice.
We accommodated everybody.
No, even then you lordship today. No, I express, at least allow me to express my gratitude.
No, not that. This is the usual practice.
My lord, I express my gratitude to
You
you.
had been serious. Mr. Bhattacharya is there, Mr. Bandyopadhyay. Both of you are senior.
You are, and apart from that, you are so kind.
No, এটা আবার kind.
Your magnanimity kind.